Hello, my name is David Fox, and I'm a patent attorney in Houston, Texas. In this video, we'll talk about intellectual property and learn something about it. There are several types of intellectual property. They are divided generally into patent law, trademark law, copyright. There's also different kinds of patents other than the standard utility patent you would think about, and those are plant patents and design patents. And then there's also trade secrets. First thing you need to know about patent law is that it's an extensive examination process going through the United States Patent and Trademark Office. And once they issue a patent, the patent is not your invention. It is only, a patent has lines, literally single sentence lines called claims. And your invention legally is only what is in those lines. So you may think your invention is on a new car, but going through the patent office, they may whittle it down to a dome light in a new car. And all you'll get is a patent on a dome light in a new car. First, we'll start on utility patents because they are overall the granddaddy of all intellectual property. They are the only form of intellectual property that cover machines, how they work, using machines, and many other aspects of that. Most other intellectual property covers, for example, their design patents. They cover what a machine looks like. That gives you a thin layer of coverage. Utility patent can be much more significant. The utility patent is the only form of intellectual property that covers real inventions. It covers the way something works. It covers how something works. It covers importing that object, using that object. It's a very strong way of protecting a machine or an invention. But there are other forms of patents that give a much weaker form of protection, and they are so-called provisional patent applications, plant patent applications, design patent applications, and those are extremely weak, and you should be very careful about those. The only one of those that potentially has value is a provisional application, but they're only good for 1 year and then they go away. So don't let anyone tell you that filing a provisional patent application is going to be what you need. Provisional patent applications, other than utility patents, are perhaps the only one out of the other ones that may give you some protection. They are filed early, and if you file a regular application for a utility patent within 1 year, you can convert it into a utility patent. But if that 1 year passes or other things happen during that 1 year, the provisional application becomes void. Utility patents generally are examined very thoroughly by the United States Patent and Trademark Office. That can take years and can be quite expensive because you have to make arguments all the way through until you're lucky enough to get your application. And once you've obtained your patent, the government Patent and Trademark Office walks away, and they will not protect your patent rights. It is entirely up to you to find an infringer and sue an infringer in a federal courthouse. If the infringer is a large company, that can involve many millions of dollars. It's not all bad news. There are single inventors, many, who have famously sued major corporations with patents that block what a major corporation wants to do, and they've obtained settlements of significant value. So that's a quick summary of U.S. patent law. I practice primarily biotechnology and biotech. However, I've practiced and also practice everything from silicon chip technology to metallocene catalyst and even candy makers. In fact, some of my products that I've patented are available now in Kroger stores, and you see them in the checkout aisle. I'd be happy to give you a free 15-minute consultation to talk generally about your invention and what kind of intellectual property we can obtain for you.